What's up, viewers, subscribers, and agents alike? It's your boy Enlightened Luciferian Prince coming at y'all once again. Welcome. Thank y'all for viewing my channel. Thank y'all for being here. I appreciate it very much. And if this is your first time viewing this channel in 2025, I tell people all the time, before you leave this video, please make sure you hit that like and subscribe button and make sure you hit all the notifications so that way every time I drop a video, you won't be left outside the loop. Now, if you're watching this video around children, please remove them from your immediate vicinity, as my videos are not for children. I say this time and time again. They're not for children, they're for the adults only, and that's the case it is. So, now that they're removed from your immediate vicinity, let me also say, this does not constitute legal advice. The sole information on this channel is for informational and educational purposes only. If you are in legal trouble, please consult an attorney if you will. Pay them your fiat, retain their services. Other than that, on this channel, it's just general information. I'm just a man who likes to read. Simple as that. So, with that being said, now that the disclaimer is out the way, let's talk about it. Power of attorney in fact. Let's talk about your fiduciary responsibilities and how you're supposed to enforce this within regards to the courts. Now, I've told a lot of people this time and time again. You have to, in your respective capacity, enforce the laws against these tyrants, against these bankers who are called the court system. Okay? Whenever you have to understand this, just know you have responsibilities to enforce, because remember, you are the holder in due course. If indeed you don't understand what that means, please get a Black's Law Dictionary or look up the legal definition holder in due course. Look up fiduciary. Look these words up. These definitions have a very significant on the outcome of your commercial affairs. Whether you believe this or not, do what you will, but I'm going to be the one to tell you, it really does. Now, let us talk about what a fiduciary is. A judge, a prosecutor, and a police officer are all fiduciaries. They have responsibilities, they also have liabilities, and they also have penalties. However, because you have been misinformed, ill-informed, uneducated, or undereducated about this, this is the reason why you need to learn how to enforce these. But you have to learn how to enforce it properly by educating yourself on what this is. Now, let's go over it. Whenever you understand that a court case is just like an account, every court case that has a number is an account number, just like a bank account, just like a loan account number. They're all accounts, okay? It's not limited, though, in a specific realm of what we call a security, because all court cases are nothing more than securities, people. I'm going to be the one to say it. Whether they want to say it or not, I could care less. Now, it says, if the security is not traded on such a national securities exchange, a price of not less favorable to the thrift savings fund, look it up, then the offering price for the security as established by the current bid and as prices quoted by persons, i.e. officers of the court too, independent of the issue or any parties in interest. Fiduciary means a member of the board, executive director, or C, any person who has exercised discretionary authority or discretionary control over the management or disposition, which is i.e. judgment in this case, of the assets of the thrift saving fund. Now, understand, any party in interest that is a part of a case has a fiduciary interest. But what they do is they switch the role of actually absolving the individual who's before the court of the liability, and then they switch what's called the principal obligation onto the natural living soul. Look up principal obligation. The government is responsible for paying the debts of the people, period. But the people themselves are ignorant to the devices on how to actually enforce this against them. Prime example, let me show you how this works. Whenever a person goes to court, let's just say hypothetically for a particular charge, right? A judge will set the bond. Look up bond in Black's Law Dictionary. 4th, 5th, 6th edition, doesn't matter. Look it up. A judge sets a bond. So now that the bond has been set, this is not what you think it is, a conditional release. Think about this. It's not. It's a financial transaction. So let's just say the judge sets the bond at $100,000, right? So now the judge sets the bond. So he then now submits a form, which is GSA. I forget the number at the time, but I will get to it in a future video. but he signs a government service administration bond. So in other words, it's a bid bond. So now basically you say, okay, now the market begins. So $100,000, they set it at $100,000 for the case, monetize it. So now you have to come up with $10,000. Let's say that's at 10%. So who has the surety? Every bondsman is bonded by every state's insurance broker. So now the bondsman basically puts up that 10K. So even though you come up with 10K to give to the bail bondsman, they already had the 100,000. So let's just say in case of default. See, this is where law goes out the door, and this is where banking starts. Because now the bond has been taken out against the surety, which is you, the natural person, which is the person who's going to sign, who's going to put up property, who's going to put up the dollar amount equivalent to basically secure your release. What has happened now is that you are no longer innocent until proven guilty, because now you are automatically placed under maritime admiralty jurisdiction. So now these individuals are basically saying you are owned by us now because we placed a fee on you for your release. Now, there are no requirements for an innocent person, but this is how the court flips it on you. So let's just say in one instance, you fail to appear. Okay, so now they put out a warrant for the surety. If you ever read a warrant, it says, attention all peace officers, constables, so forth and so on. It even says on a warrant, it even says that a coroner has the right to arrest you. I know that sounds far-fetched to a lot of people because you're not familiar with reading documents. And it is what it is. But if you read a warrant, it says even a coroner has the power to arrest the body. Yes, people, even if you are passed or deceased, you can still get arrested, which is why police put handcuffs on people after they shoot them. But this is the reality. So in other words, what they're doing is now they're placing a warrant out toward the arrest of the body because they can't arrest the corporate fiction that's on the paper. So now that 10 grand that was put down vanishes. It's gone because now they have you assured. So now they revoke your bond because they set you under administrative procedures and conditions. So you contracted before the disposition of the case. So they already got you. So I know a lot of people like, I bonded out, I'm free. No, you're not. You are held liable to the criminal action which you have not been adjudicated for at a later date. You were just on borrowed time. I hate to break it to you, but it's a sad truth. So then that so-called $100,000 was never a loss to the bond company, so now they can loan that out against somebody else who they are probably betting on fails to appear. But what you people have to understand is this. As a fiduciary, a judge is not supposed to do this. But because now you know, you should know by the end of this video what you can do and how to enforce what's necessary for you to keep yourself out of these conditions and these problems at later times. So now you have what's called the judge's oath of office, right? A lot of people talk about judges don't wish to acknowledge it. Of course they don't, because they know that by your knowledge of it, that you are going to hold them to a judicial standard, not an administrative one. Now, let's look up 28 United States Code 453. Okay? 453. It simply tells you, United States Code, Title 28 United States Code 453 is a section of the United States Code that outlines the oath of office for United States judges and justices. It's a part of Title 28, which governs the federal judicial system. However, I know a lot of people say, well, this doesn't apply to state and magistrates. Yes, it does, because it says in the Constitution, according to the supremacy clause of the Constitution of the United States, it says all judges in the United States shall be bound thereby. So when you read the Constitution, do not let this law fool you for the misreading of it. They're telling you that these individuals are duty bound by the Constitution. It's your job as the people to place them in their proper position as fiduciary, but they never taught you this. What you were taught in the respective realm of education was that you were taught to just simply obey the law. Well, no, the law is not what you think it is. The law is administrative statutes, codes, rules, regulations, and procedures for persons, which are corporations, which you are a living soul. So are you going to act like a corporation, a robot, and just let them just fill you with codes and rules, regulations to confuse you? Or are you going to act like the natural sentient man or woman and stand up for yourself and put them in a position? Right? Right. So your job is to enter into your case, any case, to make sure you file an affidavit of oath of office. You place that in the record and on the record. That way you hold that to the standard. So that way you'll always come out with a proper outcome whenever you face these tyrants, aka bankers, right? So let's look at how you can disqualify a judge for failing to provide the information necessary that you requested. Now, let's look up United States Code 455, right? Disqualification of judge. Any justice, judge, or magistrate, as I just said, of the United States corporation shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. B, he shall also disqualify himself in the following circumstances. 1, where he has personal bias or prejudice concerning a party, personal knowledge of disputed evidentiary facts concerning the proceeding. Boom. 2, where in the private practice he served as a lawyer in the matter in controversy, or a lawyer with whom he previously practiced law, served during such association as a lawyer concerning the matter, or the judge of such lawyer has been a material witness concerning it. 3, where he has served in governmental employment in such capacity, participated as counsel, advisor, or material witness concerning the proceedings, or expressed an opinion concerning the merits of a particular case or controversy. He knows that he individually or as a fiduciary, or his spouse or minor child residing in his household has a financial interest in the subject matter in controversy, or party in the proceeding, or any other interest that could be substantially affected by the outcome of the proceeding. Why do I say this and emphasize fiduciary? Because I'm helping you pinpoint what you need to know. When they say that he's acting as a fiduciary, so he has a material outcome in regards to the case, because what does he work for? What does she work for? They work for the state of. So that means that if they are judge of the United States, which is a corporation, they work for the corporate state entity, which means they have a fiduciary outcome in the matter of the case, which means that they're already biased and prejudiced, because guess what? They hold the fiduciary obligation. Okay? So now that we got that out the way, and I told people about taking the W-9 to court, this is where you get your remedy. Okay? Whenever you seek your remedy, again, as the messianic figure said in scripture, settle with your adversary before you go to court. It's the reason why the messianic figure said, Yeshua said, settle with your adversary before you go to court. Don't wait until you go to court to try to settle the matter. Because I can tell you off the muscle, you probably already defaulted and they're already waiting on you to fuck up some more and basically put your ass in jail, put you on probation, put you on a fine, a fee, or some type of program, which is called the transference of the principal obligation. In other words, since you defaulted, they're going to place you in debt. I said this years and years ago, and a lot of people totally probably ignored me or didn't know what the hell I was talking about. But now is the time. I was telling people about becoming a secured party creditor and the proper way to do it and the proper enforcement. You must know what you're doing and why you're doing it. Because irrespective of what other people say online, a UCC-1 is a financing statement. So when you file that form, you are strictly observing your rights to your fiduciary interest in commerce. I know a lot of people will not explain it like that. They want you to think that you're going to file this form and you're going to be oh so great at the end of the terms of conditions or whatever. No, you must understand that you are operating in commerce as a secured party. Now, no damn sovereign citizen, as they would like to say when you go to court, or to make you seem like you're just some outlandish belligerent. You must know what you're doing, all right? Let's straighten that out. So when you take your W-9 to court, what you're supposed to do is go to the clerk's window. This is for general purpose only. I said generational, but that may be the ancestors talking, maybe so. But at the same token, you take your W-9 to court, you take it to the window. I said this in a previous video, but I'm gonna say it again for those who first time is viewing this. You take it to the window, and you always get the name of the person in whom you're talking to. Ask them, do they have a business card? You're doing this for record purposes, or if indeed you have to go back and do some digging and make sure that, you know, this person acting on behalf of the county is basically held liable. So you ask them, do they have a business card? Come across as cordial, nice, smooth as possible. Do not come across as belligerent, because when you're dealing with this process, you better understand, you better have a lot of patience, all right? So when you ask them for their business card and so forth, you ask them two simple questions. What is the market value of the case, or QSIP number, and can you bring forth the ledger? I said this before and I'll say it again. Don't mind repeating myself in this instance, because you have to take very close attention to this. This is what's important. They'll deny it. In most cases, they'll sit there and act like they don't know what you're talking about, or they'll try to leave you at the window. You see what I'm saying? At that point forward, you wait about 10, 20 minutes, make sure somebody just take your time, just wait, see. Somebody comes up to assist you. 90% of the time, they're probably going to get somebody that's a little bit above them, right? who still probably really doesn't know, but maybe know, but not going to lead themselves on because they don't want to really leave themselves open to attack. But at the same token, they're going to be like, well, what are you talking about? Whatever, whatever. The reason why you're putting the W-9 into your case is because I told people all the time, all court cases are tax matter, period. Everything is taxable. When it deals with commerce, taxes is always at the top tier. So you tell them particularly, I'm going to tell you within regards to your failure to file this, because by your failure to file this actual form, I'm going to get the information from you. And you can look up the court's information, the EIN number, because all courts are businesses, period, people. They all have numbers, ITINs, TINs, EINs, period. They use the social, which is what they put on the court docket, to basically get the securities people. I'm drawing the lines between it so you can totally understand that this is not some shit that basically other people will try to say that that's a lie. I'm giving you all the codes, rules, and regulations in order for you to do this. So they will fail to do that, which means that now you have the power of attorney to basically act as the fiduciary in regards to this matter. You tell them, don't worry about it. I will take care of that for you as soon as possible. The reason why you can't do it is because now it is considered suspicious activity. So now, what do you do after that? Do you get the IRS on their ass? Yes, you do. Because now what you do with the IRS is you sign, you fill out, not sign. You fill out in the corrective respectability, a 3949A. What is the 3949A form? Go look it up. It talks about suspicious activity within regards to the IRS. But you don't stop there. You also file a Financial Center for Criminal Investigation. It's called the FINCEN 101. Look up those instructions. The 101 is the instructions. The actual form is the FINCEN 104. Now, this is going to two different agencies outside of the court. So once it goes to these two agencies outside of the court, you have to understand, now you are committing what is called actual investigative promptness on the court. So basically, you are no longer the liable party to the court matter because it all goes back down to the court matter. So I'm giving you the steps to take so that way, you know, you got the trail of breadcrumbs to lead you through the maze. So when you understand that, you know that this is something that you can actually do. And please do not make false statements. You might be a little bit upset, a little bit pissed off, but please keep it honest because in commerce, truth is sovereign. So keep it honest. You have what's called a Financial Center Form 104. This goes to the Financial Center Enforcement Division. So what you're doing is now you're putting these individuals underneath the radar, which I don't mind doing. And of course, you shouldn't mind either. Now, when it talks about certain things on the form, it talks about persons on whose behalf the transaction is conducted and individuals conducting transactions, right? Other than above. So basically, that would be the person on the docket, which is the straw man. Then the individuals, that would be the prosecutor, the police, and the judge. So now you're getting everybody grouped into one, the financial institution where the transaction takes place. Understand, people, this is the courthouse. It's not a bank. It's a courthouse. So that financial institution would then be considered the actual courthouse itself. I'm telling you, you can find all of this information now, this public information, but they try to keep it hidden because otherwise, if the truth comes to the light, then a lot of people will receive their remedy outside of court. But I'm telling you, all of this is necessary for you to receive your remedy because, remember, it's all boiling down to a tax matter. Not only that, you can also recoup for damages in small claims court against any and every officer acting in their capacity, outside of their capacity, but acting in it in a capacity of some type of financial gain. It's not about justice. It's not about no law. It's not about none of that stuff. It's about them receiving the interest benefit from the outcome of the securities being sold on the open market. Now, with that being said, you can also, in due respect, you can go against their bonds. You can file an insurance claim against each and every actor. And what you can do is have them run an investigation as well. So once you actually get their bonds, it's best to get their information in open court. Because now what you're doing is becoming the power of attorney. And you're saying, I'm going to handle the fiduciary responsibility of the outcome in this case because I can clearly see that y'all are incapable of doing it. And by such doing that, you are now practicing competency before the court, and they're liable to dismiss the case because they don't want you probing that damn deep. and that's in less than 20 minutes. So bring the heat to them. Simply is all I'm saying. Because again, I tell people this time and time again, my job on this channel, as I've been doing for so many years, is to tell people to put yourself in the driver's seat. Stop becoming the off-ender. Stop believing the hype and the lies that people just put up against you in a court-centered environment. You're believing you're guilty. You believe you're guilty for child support and all. It's all a tax matter, people. You can report your child support agency to the Financial Center of Investigation. You can do all of that, but you have to learn how to enforce it yourself. But if you don't know how to enforce it, they're going to keep using their policies, their codes, their rules, their regulations, their statutes and procedures to keep you as a revenue base. They're not about worrying about your well-being, because in commerce, you don't deal with live, sentient beings. You deal with dead things, and things that are dead don't feel. So just remember that. In furtherance of my channel and my endeavors thereof, if you wish to schedule a consultation within regards to this matter, don't hesitate to email me. I'll leave my email in my video description, and I'll leave it in the comment section below. If indeed you feel compelled and you feel charitable to donate for the information I've been so freely given on my channel, with irrespects to any nationality, color, creed, origin, or anything, feel free to do so. My information is also in the comment section and the video description as well. Power of attorney, in fact, people, learn how to be the proper fiduciary of your responsibilities. So that way you don't become the off-ender, but you remain in commerce as the secure party. Other than that, stay tuned for the next upload. Peace, light, love. Y'all take care. Stay tuned. And I always have to say this. Agents, fuck you. I'm out. 10-4.